This is the morning brief. Let's head to our very first conversation this morning. Bukola, you have this one.
Yes, indeed, and it's a potpourri of legal issues that we'll be exploring with our guests this morning. The running mates, the first runner-up, rather, in the just concluded, about 2 weeks ago, I beg your pardon, NBA election, has decided to head to court, citing a number of irregularities, extension of the election beyond the advertised time, non-receipt of OTP, amongst other issues. And so we're going to be talking with our guests on the implications of this. And then again, the Court of Appeal judgment, setting aside the High Court judgment ordering INEC to deregister ADC and other political parties, also gets our attention this morning. And we have joining us Mr. Libros Oshomah, legal practitioner and of course your law teacher on social media. Mr. Oshomah, it's good to talk with you again on this one. I recall after that election, you were first to scrutinize the process for us and give us insight. Perhaps this is good time for you to, just take a step back and take us down memory lane, that process. Perhaps you want to share your experience about how and if you voted, and how widespread this particular situation, Mr. Kongwe, is citing. Is it significant to call for a rerun of the process?
Yeah, Bukola, thank you. And you caught me there. And so, yes, I let me take us down memory lane. Even before the election, there were 2 suits filed at the High Court in Ibadan, one by Egbe Amofin and then the other one by the NBA, former NBA chairman of the Ibadan branch, asking that the election, by and large, the whole outcome of the suit was that the election should be, the ECMBA should be restrained. One was alleging that they were single-handedly handpicked by the NBA president, and that so they will not be fair in the process. And so the defense was of the view that the court lacked jurisdiction to hear the matter, and that secondly, even though the names were reeled out or nominated by the NBA president, but he was at what do you call it now, the NEC meeting of the NBA, and all members were present, and that if there were any objection at that NEC meeting, it would have been raised. An interim restraining order was granted and then eventually quashed at the Court of Appeal when the counsel to the ECMBA, Anthony Abdul Malik SAN, approached the Court of Appeal that alleged that the court of first instance lacked jurisdiction to entertain the matter. The Attorney General tried to step in to resolve the matter, but I think at that time it was already too late, and the directives were given, and the Court of Appeal heard that someone who is a party in a matter cannot give directive to the court. And so the Court of Appeal heard unanimously, 3 members of the Court of Appeal questioned the Ibadan High Court judgment and heard that they lack jurisdiction to entertain the matter. And then the NBA election came proper. I would say, like I had consistently said, this is not the best of elections. So I would not sit down here and say, oh, yes, like Morrissey, it is the best. But I also think that INEC should borrow a leaf from this electronic voting that NBA has adopted. I think this is the 5th time now, consistently. And in every election, right, starting from the election of our very good friend Mondo Bani SAN as NBA chairman in the Ikeja branch, when what's his name now, our friend and colleague, late now, approached the courts, asking the court to quash the process. And since that time, we've consistently had this challenge of NBA election. It's almost like the lawyers that people look up to for their election, look up to defend electoral processes, also now had surreptitiously mortgaged their own leadership selection processes to the courts. So Right from, remember, even the Polusoro time, there were allegations of irregularity. When Olumide Akpata's time also, there were allegations. I can say so many people didn't vote because the process, at some point, the process was hanging. But this lack of voting affected all candidates. It's not as if, oh, they selected a Congress candidate and say, okay, if you are supporters, if you are Congress supporter or you are Kimborough supporters, so they will not send you the OTP. So that's internet, what do you call it, a slow process, or the overwhelming process of the voters affected all of the candidates across board. So some also have alleged that it was what happened was that the supporters of Badejo were allowed to vote at early stage. Nobody stopped the supporters of the other candidate to also vote at the early stage. Like I said, all of the candidates were affected across board. It is not the best of election, but the candidate has emerged. And I doubt if the court would be able to quash the process for obvious reasons. Like I had said also at other fora, yes, certainly the other candidates, they have their grievances that they have consistently maintained that the back end, there should be an audit of the back end. I also agree with them that there should be an audit of the back end so as to forestall reoccurrence in the future. But whether we should jettison the process, because if you remember at the beginning of the process, when there was what do you call it, notice by the ECMBA that the server had been hacked, some persons were rejoicing. Why were they rejoicing? Because they didn't want the election to hold. There were a lot of people that didn't want the election to hold. What they were aiming for was that the tenure of this current executive would lapse, and then an interim committee would conduct an NBA election. Because according to them, the current president is sympathetic to the president-elect. The issue is, even these people that are alleging, can you hear me? Even the people that are alleging support bias, they also have their own candidates. They also have people who they have, a political leaning to. So everybody have their supporters. But the thing is, we need to move forward beyond all of these. Oh yeah, there are challenges. Can they be improved on? Yes, certainly they should. There's a lot of room for improvement, large room for improvement. But and also another thing, a lot of people didn't vote. I can't sit down, I can't go, from house to house, office to office, begging lawyers to come participate in an election. There are so many people who would ordinarily want to vote who could not. That is regrettable. Even some lawyers in my office couldn't vote. They waited for their OTP all through the day. They also couldn't vote. It is also regrettable. But the process, is not perfect, but it has produced a candidate. And we can only move on from here. It is not like the general election. Even the general election, when we hear politicians complain, oh yes, this election was marred with irregularity, but there are procedures for proving irregularities. Whether those procedures whether the court will be able to attain all of these procedures, it's another thing. The one for the last FB election, AFAM's election, it was just recently, just about a month ago, that the Court of Appeal finally disposed of the election petition in that matter. We are still waiting whether they will go to the Court of Appeal. So for how long can we continue like this?
Yeah, and I'm glad you wrapped up on that point, and you even began by citing some of the cases that were in court prior to this current election. And that's why I'm recalling Mr. Akongwe's position, expressed himself right here on this show when he told us he wasn't going to court because cases that were initiated during the last election have still not been resolved. But this is a surprising turn of events, Mr. Oshomah, don't you think?
No, I'm not surprised. For politicians, be it at MBA, be it at the Market Union, be it at the National Union of Road Transport, when they say one thing in the morning, just be rest assured that after speaking with their supporters, they might certainly change their mind one way or the other. So maybe left to him, he would probably want to move on. But his supporters who would be insisting, there are so many of them who will be insisting that no, they need to challenge the process. You know, we're a very litigious country. You know, we need to challenge the process, we need to challenge the process. And so, maybe, because who is a candidate without his supporters? So if the supporter says, go challenge the process, certainly he would have a change of heart. Otherwise, the next time he comes out again, he won't see anybody behind him. So the supporters might, you know, overwhelm him to challenge the process, and so he would decide whatever he had said before. If he's not able to convince his supporter to toe his line, then certainly he would kowtow to their whims and caprices. But like I had said, there is no time limit for determining the outcome of the NBA election, just like you have with the national election. So this case, and we say, oh, the windmill of justice grinds slowly but surely, but we forget that justice delayed is justice denied. The case might even be determined after the expiration of the tenure of Badijo. So why don't we, as lawyers, now there are challenges. They are all senior counsel, senior advocate at that level, all members of the body of senior advocates. Why can't they, after what had happened now, I think there's the need for a stakeholders meeting with the Attorney General and members of the senior body of senior advocate, including past presidents, to make recommendation. Henceforth, this is how we need to go to save this back and forth of, oh, we want to go to court, because people are laughing. Oh, MBA, politicians are pointing accusing fingers. If MBA that are quick to condemn INEC, now also there are complaints about the election. Even if the election is, even if every lawyer in Nigeria is able to vote, be sure that persons will still complain. You know, so that does not mean that, oh, the NBA election is like the INEC election where you have glitch. And then talking about the extension, because there was a glitch and the process did not commence as at when it was supposed to commence, and also because of the traffic in online traffic, and at some point people were not getting OTP, the ACMBA decided to extend the period, you know, beyond the time that the election was supposed to end. So extension of the period does not necessarily mean that it was only Badijo's supporters that were voting. Others also voted. So if you look at it, fair and by and large, even if you want to say that the process was not all too transparent, but you can still at least give it a 55 to 60%, you know, pass mark.
Whether that is fair enough or speaks well about the NBA and how you lawyers like to pride yourselves as, you know, learned silk and all of that is also questionable. That those also asking, for instance, going down memory lane, have you know, previously, and all the controversy surrounding NBA elections in previous elections, have people gone to courts, and what is the outcome, or what was the outcome in such events? But let's take a moment. We'll come back to the NBA issue, Mr. Oshomah, because we need you to speak to this burning issue from the appeal court reviving the ADC and 4 other parties. In fact, the appeal court described that judgment as judicial rascality. I wonder what you make of this, plus the fact that, you know what, there are those who are even calling for the probe of the judge, Justice Peter Lifu, who are saying that, you know what, he should be probed for such a judgment. I wonder how you respond to these issues. Mr. Oshomah.
Can you hear me?
We can hear you loud and clear, Mr. Oshomah. Go ahead.
Okay. So, the issue, I was at your studio, I think a day after that judgment was delivered. And I did say that I wonder if anybody had a gun to Justice Peter Lifu's head for him to deliver such a judgment. I don't want to use the words that is coming to my mind now to describe that as judgment, especially considering the fact also that the Court of Appeal had before then asked Justice Peter Lifu to stay proceedings in the matter. We all know, every elementary law student know the hierarchy of courts. The Court of Appeal cannot be seized of a matter and the lower court is on head-on collusion with the Court of Appeal. That is forbidden. It's a taboo. It is judicial rascality, just the same way the Court of Appeal had described it. But however, the issue here now is that I wonder the face or the how those people who were supporting Justice Lifu's judgment and trying to rationalize it, looking for how to describe it, and then looking for Supreme Court authority to say that if a judgment has been reserved, you cannot arrest a judgment that has been reserved. Meanwhile, as at the time the Court of Appeal asked for stay, judgment had not been reserved in the matter. And so, another thing I did say that INEC, by virtue of that section 225A, INEC is the agency that is statutorily responsible to deregister. INEC had deposed to an affidavit in that matter to say that these political parties had met the threshold. And what was the threshold? Win at least a councillorship. Even if you do not win, the Supreme Court had said, even if you do not win, but you are in court challenging the outcome of a local government councilship election, that you cannot be deregistered. Against the backdrop, all the five political parties, INEC had shown copiously that they won elections at the local government level, at the House of Rep, House of Assembly. And be that as it may, even the people that filed the suit also have not shown two things: that they are a juristic person capable of suing and being sued, and then also that they've not shown any interest that they will suffer in the matter, just like the Court of Appeal by Justice Wike has said, any injury they will suffer if the parties are deregistered. Rabble-rousers just woke up, approached Justice Lifu, and Justice Lifu, despite against overwhelming evidence, decided to listen to them. That is why people now are calling on the NJC that if you can be so much in a hurry to yank off, to suspend Michael Zekome from the enviable position of the silk, why also are you so lackadaisical and laid back in looking at all of these conflicting orders and the insults and affronts that a judge of the High Court had heaped on a Court of Appeal? Why that's what people are saying. No, look, this is not just a judge giving a judgment, because you can say, legally speaking, you don't punish a judge for delivering a judgment because it does not tally with the Superior Court judgment. But that is not the case here. The case is that the judge, despite an order asking him to maintain status quo, he went ahead against that order to say, like my grandfather would say, bloody fool, I will go ahead and do whatever I need to do.
It's interesting. Even for non-lawyers, it's as basic as 1, 2, 3. I remember this same ADC case. Remember the Nafi Bala case, where that interlocutory appeal went all the way to the Supreme Court. On the day the Supreme Court was to hear the case, the trial court was also to hear that case on that on the trial process. The court, I think Justice Muhammad Umar, had to suspend it sine die, pending what comes out of the Supreme Court. So we're really shocked that first there was a stay of proceeding from the appellate court, it still went ahead. So, but the NJC will make a determination of his fate, because I remember also there is one of the judges that have been listed as court of concern or public concern. Court of concern by the Tunami Turaki group. About certain judges being assigned PDP cases. He was listed, Peter Lifu was listed, James Omotosho was listed, I think Judge Abdul Malik was also listed. So all of this is not looking good for the Judex, but that's the decision.
No, I don't, that for me, I do not have a problem with whoever is assigned these cases, because courts, admin judges, what sometimes they use practice direction to segment the court. And so, for professionalism, so even in Lagos State, even though in Lagos it is clear-cut hierarchy, it is clear-cut distinction, you have criminal division, you have family and probate, you have general, then you all of that. But in this case, for example, even before that was done here, there was a time where if the judge is handling criminal matters. The tendency for the admin judge to consistently, assign criminal matters to that court, is very high. So if some judges, certain judges are handling, political matters, and they've shown to be swift and fast because of the nature of those cases, it is also common for the admin judge to assign those cases to them. For Turaki, who is a senior advocate, should understand all of these things, that it's not because they have special interest, but because, or if you go to those courts, you find out that a lot of the matters in those courts are politically exposed cases. But that also should bother the judges. The fact that people and every judgment that is coming from your court, people are beginning to raise concern and questions about them, and the Court of Appeal are consistently knocking you, then should be a cause of concern for such a judge. Just last week, I think Justice Umar, two judgments from his court were, nullified by the Court of Appeal on political matters also on INEC, and I think that it should call for concern. But whether they are assigned cases, for me, it's a normal, practice by the judiciary.
It is, well, I don't want to go to the politics, but we understand where all of this, because you remember when the Yeson Wike and his political godson now reconciled football fighting, we realized that every case that came from River State kind of favored the governor, the ones that were in Abuja. Yes. Kind of
so see, John, let me take your mind back. This same PDP, yeah. Remember the Modu Sheriff faction and the McAfee faction.
Yeah.
In 2015, immediately they left office, you had every judgment that came from Abuja would favor the Modu Sheriff faction. Every judgment that came from Port Harcourt, Wike was governor then, would favor the Ahmed McAfee faction. So it was a pendulum, it was a sing-song. Today Abuja will give judgment, tomorrow the Port Harcourt will give a completing judgment. So we are seeing it again happen, during that impeachment, resignation or no resignation, sack of the House of Assembly members, or sack of or not. The State High Court dabbled into the matter even though they didn't have jurisdiction, and then the Federal High Court in Abuja, it was almost as if they were doing the bidding of the Godfather in Abuja. So when things like this happen, that's when people now begin to second-guess the judgment coming from court. Gone are the days, some lawyers would say, very senior lawyers would say, gone are the days that when you look at the set of facts, you can, beat your chest, go to sleep and determine that this certainly will be the outcome. But these days, it is no longer so. You hear that a very minute matter, like this case of the Deregistry, you are now beginning to wonder. It's like looking for fishing for fact to sustain, an outcome when there is none. And so everybody now begin to second guess the judgment coming from a judge whose ideas are supposed to be in heaven. It is not good at all. It is not good for the judiciary. Senior lawyers should speak up, and the judges at their conferences also should talk to themselves, because there are so many good judges in Nigeria. I know some of them, know many. But when you continue to elevate these bad ones, and it is their judgments that are read politically, publicly, certainly it gives the entire bunch, the entire crops, the entire judges, both the good ones, the bad ones, the not too good ones, it paints them in a very bad light. So at the judges' conference also, I think they also need to talk to each other, talk to one another. And then when judgment like this comes, that is why for me, Bukola said, the street professor, online professor, yes, I take my time to use the everyday language, pidgin English that people will understand, to explain, so that, because there's so much illiteracy out there. So some people who do not understand this thing, begin to throw punches and, in different directions. So I take my time to reason and explain it in everyday language so that people will understand the reasoning behind this thing, because almost everybody now has become a lawyer. So what are the rationale? What are the ratio decidendi, like we say in court? What are the facts of the case? Because some people don't even read the judgment, they just go to town with it. But the judges also should help us, so that when we do this thing, we'll be able to say, well, this one, yes, it is not the fault of the judge, because the judge is not a Father Christmas. It is the fact placed before him. But when the fact is overwhelming, the documentary evidence is overwhelming, and then against all of that, the judge, like Justice Lifu, close his eyes to all of those evidence and then give a contrary judgment, and the Court of Appeal says this is judicial rascality, that in the first place, the court does not even have jurisdiction to entertain the matter.
So, Mr. Oshomah,
the people before him were not proper persons.
Let's expand the argument a bit further. You know, some would say when you go to certain courts and it's some weekend matter, you know, you can predetermine what the outcomes are. I don't want to mention the names of the judges, but this Court of Appeal judgment, let's look at the markings. It's a unanimous judgment. It awarded cost against the body that it said it had no jurisdiction, the Association of Former Legislators, and it's a Court of Appeal judgment. Shall we then say that if a case gets to the Court of Appeal, indeed justice will be done and would have been seen to be done? Or should we look at other Court of Appeal judgments in other cases and also ask for, you know, judges to be more above board even at that level? Are we saying that there are certain levels where indeed, you know, justice can be relied upon to have been done?
Let me take the Turaki faction allegation, for example. No matter the relationship that Wike might have as a member body of benchers, no matter the relationship it might seemingly have with the profession, and also as a lawyer, I also think that the opposing party, in some cases, you know, play themselves into the hands of this man. Before I go to Wiki, let me start with the NBA suit. When that action was filed in Ibadan High Court, there was the presumption that, since the senior lawyers involved in the matter plied their trade in Ibadan, that the court in Ibadan was going to be favorable to them. But at the end of the day, the Court of Appeal said otherwise. That's on one side. Also, the Turaki faction, for example, the court went and told them point blank, don't go ahead with your convention. Don't do it. Hold on and wait for the outcome of this court determination. It was Lamido, Lamido, former governor of Jigawa State, that approached the court. And the court said, well, by your constitution, you cannot deny him participation. But they went ahead. By going ahead, they played into Wike's hands. So if at the end of the day, the set of facts that the court looked at to determine the case, can you fault the court in such circumstances? Also, if you remember, I talked about the Wike and his godson. The matter at the High Court in Rivers, Port Harcourt. The question remains, does the High Court in Rivers have the jurisdiction to determine membership of the House of Assembly? The answer is no. But when you go to such direction, you play into Wike's hand. So it's almost as if the man is very smart. He's a litigious person. He understands the process. But because his opponents are always in a hurry, so it looks as if the courts are always favoring him. So you have to be strategic. You have to be systematic. That is why. Look at the Court of Appeal cases.
Yeah,
cited.
We must answer at this point, but this sounds very much like another law class. We must thank you very much for coming. Mr. Lifu Oshomah is a legal practitioner, constitutional lawyer. Thank you for coming on the program. We'll take a moment now. When we return, we have two more places to touch. There's the matter of security. And of course, we'll return to opposition politics, but this time around, a bit more far removed from the legal terminology. So stay with us. We'll be right back.